Welcome to my YouTube channel. I'm your entrepreneurship tutor, Professor Henry Buisa of Jomo Kenyatta University of Agriculture and Technology. Today, I'm talking about Kenya's Chief Justices who judged without fear or favor. Yes. In 2017, Kenya's judiciary made a history when it became the fourth globally after Austria, Ukraine, and the Maldives, and the first in Africa to nullify presidential elections. Today, the 21st of March 2022, Kenya's judiciary scored again by boldly and without fear or favor, declaring an initiative by the president of the country to amend the constitution as unconstitutional. But in both cases, each of the judges on the bench had his or her own argument, and only the majority rule showed the way. In 2022, the prayer was it proper for Kenya's President Uhuru Kenyatta to initiate an amendment to Kenya's constitution via the Building Bridges Initiative? And the verdict was an emphatic no by Kenya Supreme Court bench of 7 on this 31st March 2022. Now, my satirical lines, with the satirical lines. Justice Mother mothered it all, prompting Justice Ouko to okay it, and Justice Isaac to zigzag through his agreement, this triggering Justice Smokin to smoke it out in Queen's English, provoking Justice Njoki to joke others with disapproval, dwarfing Justice Muhammad to murmur his verdict, and finally, Justice Philomena Mwelo philosophically mouthed it. Yes. Let's hear the individual justices. Now, cutting a motherly figure, Kenya's Chief Justice and the President of the Supreme Court of the land, Martha Koome, went against some expectations that she would favor the president to passionately stamp the authority of the apex court of the land. Let's listen to her.
As the apex court in the land and custodian of the Constitution, it is not lost to this court that we are being called upon to provide an impartial and authoritative determination which will guide and act as an interpretive compass to the courts below, to the state agencies, and to all the persons to Unity Project. The question before the court is a narrow one, and it relates to whether a constitutional amendment process initiated by the president can be pursued through a popular initiative route prescribed in Article 257 of the Constitution. To answer the question as to who may initiate an amendment process through a popular initiative requires that we understand the purpose that is intended to be served by introduction of the popular initiative as a route for amending the Constitution. This is pursuant to the purposive interpretation decreed by Article 259 of the Constitution. The Constitution making history that I have highlighted demonstrates that a popular initiative was a tool carved out exclusively as a route for constitutional amendment by citizens. In essence, amending the Constitution through a popular initiative was intended to be a citizen-driven and a citizen-centered process. The citizen-centric nature of a popular initiative is linked to the fact that it is conceived as a means for direct sovereign power to be expressed as contradistinguished with the parliamentary initiative, which lies to the realm of the derived or delegated sovereign power. Under this understanding, the popular initiative is supposed to be triggered from below at the initiative of the citizenry, as opposed to representative institutions. In other words, the popular initiative is intended to give citizens acting outside the institutions of the state a means to activate or trigger the exercise of their sovereign power. This understanding of the centrality of the citizens in activating a constitutional amendment process through a popular initiative is projected in the book that was referred to us by Joe Coron Lois, titled Constitutional Power and the Law. My analysis of Article 257, the history of constitution-making process, and the authority cited in the said book, although persuasive, indicates that a popular initiative is an exercise of direct sovereign power that excludes the representative institutions, that is, the legislature and the presidency, which only exercises power that is derived or delegated sovereign power as distinguished in Article 1, 2, and 3 of the Constitution. In other words, it is a means of direct democracy, and indeed direct democracy can only be exercised by the people, not their representatives, since that would convolute the form of democracy at play. It follows, therefore, that a popular initiative in a constitutional amendment process ought to be seen as an avenue through which citizens engage in the exercise of their sovereignty. As such, state organs, being not bearers of direct sovereignty, have no right to activate the popular initiative. This leads to the conclusion that the popular initiative is a preserve of the citizens, the one popularly known in Kenya as the Wanjiku. It ought to be appreciated that the Constitution provides normative markers for how, when, where, and by whom particular powers are to be exercised. Article 257 delineates who has the power to undertake what duty or obligation as a right to undertake specific measures with respect to the constitutional amendment process. It is in appreciation of this that I need to interrogate the argument that the institution of the presidency has the authority to initiate a popular initiative in light of the overarching right motive of the Constitution, which is concerned with tampering or limiting the powers of the presidency. In its architecture and design, the Constitution strives to provide explicit power to the institution of the presidency and at the same time limit the exercise of that power. This approach of explicit and limited power can be understood in light of the legacy of domination of the constitutional system by imperial presidents in pre-2010 dispensation. As a result, Chapter 9 of the Constitution lays out in great detail the powers and the authority of the president and how such power is to be exercised. Another reason that supports the finding that the president was not envisaged as an initiator of a popular initiative is the role of the president with respect to entrenched matters listed in Article 255, 1 of the Constitution, Article 256.5 as read with Article 257.10 of the Constitution, which grants the President a law that can be typified as serving as the guardian of the amendment process. In that, where a constitutional amendment bill is presented for assent, the President has the obligation of reviewing the bill and referring the bill to undergo a referendum process where it involves matters listed in Article 255 of the Constitution. Such a guardianship role over the amendment process ought not to be undertaken by the prayer in the amendment process. I therefore endorse the finding by the two superior courts that the President ought not to be both a prayer and an umpire in the amendment process.
Yes. Now, it came with little surprise that William Ouko, a 60-plus-year-old and Kenya's appeals court president, known to be a down-to-earth judge who loves music, books, and who is described by colleagues as humble and team player, okayed. In other words, Ouko okayed mother in quotes, mother's judgment.
The forms. The conclusion I reach should be apparent on the first limb of this ground is that the President, as a matter of fact, commenced and spearheaded the process from its inception and only passed on the baton to the two co-chairpersons when it was too late in the day and beyond recall. That the President is ineligible to directly or indirectly initiate a constitutional amendment to the Constitution under any of the prescribed circumstances. That he cannot act as an ordinary citizen because he is not, and at the same time claim to be exercising executive authority. He cannot, in the circumstances of Chapter 16, run with hare and hunt with the hounds. It has been argued that by barring the President from initiating the process of constitutional amendment, his right to equality and freedom from discrimination would be violated. The nature of violation has not been demonstrated. Looking at the facets of the rights and fundamental freedoms under Article 27, I cannot see any that could be breached by simply asking the President to stay on his lane of constitutional amendment process. Similarly, the guarantee of his political rights, which are specific under Article 38(1), that is to make political choices, to be registered as a voter, and to vote by secret ballot in any election or referenda, have not been violated. The President's role in the constitutional review process has been preserved and is intact. The power to assent to a draft bill passed by Parliament and to request the IEBC to conduct a national referendum for approval of the bill are indispensable roles and essential cogs in the process. Apart from this, the President, as indeed any other voter, is entitled to support a popular initiative by signing it, and in fact, he did so in public. Indeed, nothing stops the President from campaigning for or against the initiative. For these reasons, I agree with the learned justices that to the extent that the President took certain steps and actions at the inception of the popular initiative process, as explained, the entire process was irredeemably flawed. I would, in the result, affirm the conclusion.
Yes. And then just like in 2017, when he was among the judges whose judgment nullified the presidential elections, Justice Isaac Lenaola sacked, in quotes, his strength of judgment and went ahead to judge against the president initiating an amendment to the Constitution.
Judgment. I have looked into the history of Article 257, and if you look at the CKRC reports, Article 257 was intended to be exercised by the common man and civil society, and not anyone outside that category. I have therefore no hesitation in holding that the President cannot and should not initiate amendments to the Constitution under Article 257. Like George J.A., I'm certain that popular initiative is people-centric, and while the President has certain rights as a citizen, there are certain other things that are curtailed by the Constitution as regards him. The President cannot initiate the process by collecting 1 million signatures and crafting an amendment bill and then to retire to await the same bill under Articles 257(9) and assent to it as President. That is an absurdity that could not have been the intention of the framers. Neither can he initiate a bill under Article 256(5)(a) and then under B request the IEBC conduct within 90 days a national referendum for approval of the bill and then retire to assent to it as the President. And therefore my finding is that he cannot initiate a popular amendment under Article 255. But I've said, knowing the politics of this country, if the President has parliamentary muscle, he can then invoke Article 256 and initiate amendments through Parliament.
Yes. And then Justice Smokin Wanjala sat on the bench in 2017 to hear the petition against President Uhuru Kenyatta's election. He, however, went conspicuously missing during the delivery of the full judgment. This time around, he came out literally smoking his verdict against the same president, using what one would call the Queen's English.
Of that article, it cannot have been lost on a casual observer of our painful history that it was the imperial presidency that mutilated the independence constitution through unchecked amendments to such an extent that at the end of the day, this country had lost any pretensions to democracy, rule of law, human rights, or social justice. And by the early 1990s, the Kenyan people were terrified, tormented, and dehumanized a lot, deprived of any sense of self-actualization in the manner in which they were governed. It was from such despondency that the people would rise to demand a new social contract, a new order that would not only restore their dignity, but also prevent the executive arm of government, if you like, read the president, and to a certain extent the legislature, from reversing the new equilibrium, from taking them from the paradigm shift to which they had cutted themselves. And so to this question, I have no hesitation in holding that the president cannot initiate a popular initiative. That takes me quite quickly as to whether indeed the president did initiate this popular initiative. It's on record via the Gazette notice number 514 dated 24th May 2018 that the president appointed a task force named the Building Bridges to a United Kenya Task Force, or the BBI Task Force if you like. This task force was composed of eminent Kenyans whose mandate it was to address the 9 key challenges facing the country. And these challenges have been identified in a memo of understanding signed between the President and Right Honorable Raila Odinga. Thereafter, the President, via Gazette Notice number 264, published on 10th January 2020, appointed a steering committee on the implementation of the Building Bridges to United Kenya Task Force report. One of the terms of reference of that steering committee was to propose administrative, policy, statutory, and constitutional changes that may be necessary for the implementation of the recommendations contained in the task force report. It is out of which the steering committee that we now have the Constitution of Kenya Amendment Bill of 2020. I, on my part, find, although the High Court later described the task force as an unconstitutional outfit, I, on my part, find that there was nothing unconstitutional in the appointment or composition of either the task force or the steering committee by the President. What remains is whether the President can be regarded as having initiated the process that culminated into the bill that we now have. And in conclusion, I have stated that taking everything into consideration, all the stages, all the processes that led to the bill, I find it difficult to distance the President from the involvement and the initiation of the popular initiative. Therefore, I find that the President did actually originate this initiative. The concluded consideration, not just by this court, by any other court in this country. Before I sign off, my mind races back to those 3 days in this tent during which I and my colleagues here sat patiently, pensively and attentively listening to the impassioned pleas from the bar so commandingly assembled. Not that this was the first time I was finding myself having to endure the perorations of counsel. Some of them experienced jurists and others not so senior. But it was such a moment when the basics of a basic structure were basically spewed unto us with such aplomb, hitherto unseen, save during the hearing of a presidential election petition. What we were told, however, I also remember that it was on such occasion that we were reminded that our colleagues at the High Court and Court of Appeal, the colleagues at the High Court had built a foundation, and those ones at the Court of Appeal had constructed a wall upon it, and that now it was our turn to paint that wall. But we were not told with which colors we were to undertake this alluring task. I also remember being urged to roar like lions in the wild as we asserted the supremacy of the Constitution. But who could fault counsel for invoking our hallowed symbol of nationhood? Yet at that moment I could not help but cringe, for the sound of a roar of a lion in the wild stirred in me images of the terrifying language so beloved by our politicians, the language of tsunamis, of earthquakes, volcanoes, war and thunder. And that is why I cringed.
Yes. And then Justice Njoki Ndung'u did it in 2017. She did it again in 2022, standing out against the pack. Njoki literally choked the listener, trying to explain that the president is as ordinary as the ordinary citizen in many ways.
The Constitution is categorical that all sovereign power belongs to the people of Kenya and shall be exercised in accordance with the Constitution. Further, in that article, sovereign power may be exercised either directly or through their democratic elected representatives. The National Executive enjoys delegated sovereign power under Clause 3 of Article 1 of the Constitution, and according to Article 36(1) of the Constitution, the President shall be elected by registered voters in a national election conducted in accordance with the Constitution. In addition, Article 1 of the Constitution elaborates the tenets of a functioning republic, anchored in the concept of libertas populi, which defines the characteristics of a functioning republic. It envisions a system that has responsible citizens who exercise their rights democratically and consciously. A free res publica is the highest value of all for citizens. Article 1 preserves the exercise of the actual legal authority or power, which is exercised by the people directly or through their democratically elected representatives. From the foregoing, there is no doubt that the President is a democratically elected representative of the people who, under Article 1, can exercise delegated sovereign power of the people. Indeed, this is one of the ways in which constituent power is exercised under our Constitution, and therefore I am confounded by the fact that the superior courts address the constituent power of the people at length, but for whatever reason fail to take into account that the President is a directly elected representative of the people and he can exercise delegated power on their behalf. Furthermore, it is a fundamental right of the Kenyan people to elect their representatives, and that those so elected to speak on their behalf. To limit the ability of an elected representative to speak, to act, to work on behalf of his or her electorate is itself a limitation of the people's political rights under Article 38 of the Constitution. Such proposition would amount to limited republicanism, limiting the extent to which people exercise their powers either directly or through their elected representatives. More poignantly, however, limiting the powers of the people donated to the elected representatives reorganizes the architecture of the Constitution's order of delegated governance. It is not in dispute that the President bears an elevated status by virtue of his office. The President has additional roles and obligations in comparison to the ordinary Kenyan. In addition, Article 132 of the Constitution mandates the President to safeguard the sovereignty of the public, promote and enhance unity of the nation, promote and respect the diversity of the people and communities of Kenya, and ensure the protection of human rights and fundamental freedoms and the rule of law. Article 132(1)(c) of the Constitution stipulates one of the many mandatory functions of the President. The President must, once every year, report in an address to the nation on all measures taken and progress achieved in the realization of the national values referred to in Article 10. In my considered view, the President is not limited as to those measures he can take to undertake he is not limited as to the measures he can undertake in the exercise of his functions under Article 132. The said measures could constitute a policy, statutory, or constitutional frame. Clearly, in promoting and enhancing national unity, the President can promote constitutional amendments through popular initiative.
Yes. And then Justice Muhammad at times murmured when reading his full judgment, but the murmuring stopped and he was emphatic on why the President cannot participate in a popular initiative to change the Constitution.
And state my disposition without going into the details, and I leave that to you to read when you have the time. Regarding question 2, Gatebu J.A. rightly observes that Article 257 makes no qualification of who may or may not promote a popular initiative, and there is no explicit bar against any person, including the President, from promoting a constitutional amendment by popular initiative. It is therefore upon the court to interpret and determine the parameters of the same. Now, Justice Tuyot gave the historical context of highlighting the genesis of popular initiative, the clauses in the Constitution. This can be traced back to the CKRC final report, where the Commission noted that although the Conference agreed the process of constitutional amendment, this must not be left entirely to Parliament. Different options needed further thought, particularly with regard to the exact modalities of engaging the constituent power of the people. The Commission, in addressing the issue, recommended that citizen and the civil society may initiate constitutional amendments through a process called popular initiative. This was then captured in the zero draft at Article 346, and the same was retained in the Boma's draft as follows, and I quote, an amendment to this constitution may be proposed by popular initiative signed by at least 1 million citizens to vote. So the genesis of the issue of popular initiative was way back during the CKRC conferences. The same survived the Naivasha Accord of November 2004 and the Kilifi Accord of June 2005. And also, it was retained in the harmonized draft. The objective for the popular initiative, as captured by the final report of the Technical Working Group of Group K of the Constitution of Kenya Review Commission on Constitutional Commission and Amendments to the Constitution held up to the creation of 2010 Constitution, the report said, a committee introduced a novel idea called popular initiative. This is an innovative where the citizen can only by their own motion initiate amendment to the Constitution by way of a popular initiative, either in the form of a general suggestion or a formulated draft bill. The committee explained that their intention was a starting point towards curbing dictatorship by Parliament. Tuyot J.A. went to hold that, contrary to the AG's submission that the intention of the popular initiative was to curb parliamentary monopoly for both people and state organs, the historical perspective demonstrated that the popular initiative was a preserve of the citizens. It's for this reason that I concur with Kiage J when he concluded that the popular initiative route must be citizen-conceived, citizen-initiated and citizen-driven process, and the citizens are the ordinary people, whether as individuals or as organized civil groups.
Yes. And she was the last to read her judgment. And Justice Philomena Mwilu literally mauled the president. One may say that just like in 2017, Justice Philomena needed no deep philosophy to present her verdict.
The second issue, the president, in my reading of Article 143, cannot, no, not 143, sorry, Article, issue number 2, the president cannot directly initiate changes or amendments to the Constitution. An amendment of the Constitution can only be initiated through a parliamentary or popular initiative under Articles 256 and 257 of the Constitution of Kenya 2010. Consequently, therefore, the Constitutional Amendment Bill 2010 is unconstitutional.
Good. And that is how they ended. 7 judges, only 1 supporting the president, 6 saying the president has no authority or it's not right for the president to initiate a popular initiative. And that's how fear or favor was thrown through the window and law persisted.